Stephanie Bailey versus William Roth. Attorney Thomas Schaefer for plaintiff and attorney Allison Greenlee Core for defendant.
Okay. Good morning to everyone.
Good morning.
Morning.
This matter is before the court for two matters: the plaintiff's motion to change custody and parenting time, and defendant's motion to hold plaintiff in contempt for make-up parenting time and to enforce the court orders. So, I guess at this point, unless Ms. Corey, you have any opposition, I'd have Mr. Schaefer again proceed in this matter, because I think that'll, as we go through, we're going to be able to address all those issues in any event.
We did file our motion first. However, I'm fine with just kind of dealing with both matters at once.
Okay. Well, I thought kind of the issue of the custody issue will kind of drive things, so I just thought it would probably be easier and more efficient if we handled it in that particular manner. You're always, because you file it first, you're always entitled to go first if you want.
We're prepared to go first, so I prefer to move forward in that capacity.
Okay, well, we'll do it in that manner. Let you proceed with yours, and then we'll go to Mr. Schaefer at that point. So, Ms. Kaur, do you wish to make an opening statement?
Just briefly, with some history in this case, Your Honor. As this court knows, we've been back and forth on this matter since May of 2023. That is when the parties determined that it would be in the minor child's best interest for the child to go and stay with mother's family for a short term while they were figuring out what was going to happen with this infant minor child legally. Mother then picked up the child from her family's home and has withheld the child from Mr. Roth ever since. Mr. Roth has only seen the minor child once since that time, and that was when mother brought the child over on September 11th, but didn't have the child get out of the car. Mother has since that time violated almost every single order that this court has ordered. She has kept the child from my client. She has not dropped the child off. And as of September 11th, if the child wasn't delivered to my client, she was supposed to be surrendering herself to the Calhoun County Sheriff to be incarcerated. As you can see, she's sitting here today and she did not do that. We're looking today to hold her in contempt, civil contempt. We're looking to suspend her parenting time. We're also looking for make-up parenting time if her parenting time is reinstated in the future. My client, again, hasn't seen his child since May of 2023. He hasn't had any overnights whatsoever. Additionally, if this court recalls, Ms. Bailey kept the minor child out of school from May until the end of the school year, and was ordered to enroll this child in the school that the child has attended for years, Allegan County, and didn't do so. So at this point, we do believe he's enrolled in school. We're not entirely clear where, but the child is enrolled in school somewhere. But I want to point out the order dated 8/16/23 clearly said that the child will attend school in Allegan County. Mother violated that order clearly. Again, I think this is a very, very clear case of contempt. Mother needs to be held accountable. Mother has flaunted the rules of this court, the orders of this court, and her motion regarding custody, frankly, is just frivolous. Mother has been in and out of this child's life. She's behind in child support. She has not had significant parenting time with this child since 2011. If this court looks back at the case history, which I understand the case file is long, and I understand that there might be some things that are out of order, but my client was granted sole physical custody, and there are reasons for that. Mother has severe mental health problems. Mother's home is inappropriate. Mother has other issues behind why father was granted sole physical custody in the first place. Her motion to modify custody based on her violating his court's orders, frankly, is ridiculous. And we believe her motion should be completely dismissed and set aside. She should be held in contempt and her parenting time suspended at this time. Thank you.
Thank you. Mr. Schaefer, do you wish to make an opening, or do you wish to reserve or waive your opening?
I wish to make an opening.
Okay, go ahead.
This is a matter that has been obviously ongoing for some period of time. And we have filed a motion to change custody based on a change in circumstance, as we have alleged that in May of 23, which was the parenting time of my client, it was disclosed to her by her son, who was
Your Honor, I'm
now
going to
14.
object to any sort of hearsay coming from Mr. Schaefer.
This is my opening statement. I remain quiet of all the things that were before, so I don't know what the problem
Well,
is.
it is its opening statement. Again, the court would, sustain any objection when we get into proofs on this matter, but I'll let him go through with his opening statement, no, recognizing it's not evidence.
I submit it is probably admissible based on what client did and what information she had, but she was advised by her son that being abused by his father continuously, the last time in April of 23. And as a result of that, he advised his mother that he was not going back to his father's. This was made apparent to the other side. They disagreed, obviously. And subsequently, as indicated, court ordered that my client deliver the child on September 11th to the home of the father, which she did. She delivered the child there. The child was at the home. There was a police officer there. There were other people there. My client allowed the father to retrieve the child. The child apparently not go with the father. My client complied with the order. She delivered the child. She is not in violation of the order. She did everything she was supposed to do. The officer there not physically remove the child from the car. Apparently, the father did not physically remove the child from the car, but the child was delivered. The motion to change custody is a valid motion from the point that we have an abusive situation in the home of the father as it relates to this particular child. There is history in here that there was difficulty in this relationship to the extent that the CPS got involved when there was an allegation that the child had improperly touched a half sister in that home. And there were some pleadings and efforts to keep the child from talking to the police because both parents have joint legal custody of the child. That was not with. We had some orders in that regard. There was a short period of time that the child was placed with my client to protect him. And that matter is pending out there, but it is what it is at the moment. But subsequent to that, it came to the attention of my client. Her son has been abused, that he has indicated that to her, and she acted to protect the child. And she did that by filing this motion, asking for an in-camera meeting with Caden and the judge, and that took place this morning. And all I can say is that my client has responded to the allegations that are presented to her. The child has shown here to go back with the father. He has expressed he's not going back to the father. And as a result, there's not much that my client can do short of physically grabbing him from the car and wrestling a 14-year-old to his father. Apparently, his father was not willing to do that when the child was delivered. But the horrible situation that the relationship, for whatever reason, either because the child is being abused or because they're not getting along, that the child is expressing this information, whether it may be secondary at this point, but the relationship between the father and the son is so awful that the child is not willing to go with the father and is fearful of the father. If this relationship is going to be saved, I think there needs to be some counseling between the father and the son to deal with whatever the issues are, whether it's abuse issues or not. I'll indicate to the court that the proofs are going to show there's an ongoing CPS investigation in relation to these abuse allegations. There is an investigation through the Sheriff's Department in Allegan concerning these investigations, none of which have come to total fruition at this point in time. My client is in the middle of a situation where her son has indicated to her that, number one, he will not go back to the father. Number two, he's fearful of going back. And number three, that he's been abused by his father. As a result of that, my client has followed the orders and the child is still refusing to go with the father. There needs to be a remedy. I think there needs to be some counseling. I think there needs to be some temporary orders or permanent orders of either changing the custody to my client with Caden to protect him and to foster the relationship. The proofs are going to show my client has a proper home, has a proper relationship with the child pursuant to the best interests of the Child Custody Act, that she has a stable life. The proofs are going to show that there is instability on the other side. There's abuse of alcohol. There are drunk driving charges on the other side that go to certain elements of the child best interest of the criteria of the child custody. Those will all be explored in this regard, Your Honor. Unfortunately, Your Honor is set with a situation, I believe, that the child is refusing to go to his father. That's a decision the court's going to have to make, but we don't believe it's in the best interest of the minor child to force him to do so under the allegations that have been made. We're going to ask that there be a change in custody to the mother for Caden based on those facts.
Okay, thank you. Well, as you brought up, and the court wasn't aware that there was a CPS investigation. I think we probably had that someplace in the proceedings. There had been some mention that had been referred. I didn't know that there was an ongoing investigation at this point.
It's been closed, Your Honor.
Oh, has it?
Closed. It's been closed along with the police investigation. They were both closed. Yes.
Okay.
I talked to the CPS worker yesterday. I did not get that information, Your Honor. And my information from the detective was that the investigation has been done, has been sent over to the prosecutor's office.
Your Honor, the prosecutor has denied to press any charges. And that's information that we were told Mr. Schaefer's office was provided directly.
Okay.
And I will note that the police investigation and the CPS investigation, that is the reason why this court originally granted Miss Bailey temporary custody, because Miss Bailey argued that the child shouldn't be speaking to the police and shouldn't be speaking to CPS, yet then took the child to the police and to CPS. So
if I may respond to that, Your Honor.
Yes, go ahead.
Two separate events. The initial one was the subject of an alleged touching in the home of his father. That was the first event. The second CPS matter has to do with the investigation of the father in relation to his actions toward Caden. Two separate events.
Okay. So, Ms. Carr, do we have a closure on the instance involving Caden, but maybe not on the second one?
Your Honor, it is my understanding the prosecutor's office has declined to pursue anything against my client. And my client was provided with a safety plan from CPS and was told that everything was unsubstantiated and that they were going to be closing the matter after the 30-day deadline, which I don't know what the deadline is.
Yeah.
I talked to the CPS worker yesterday, Your Honor, and I got a lot of nothing back from her as to the stage at which the investigation, but the impression I got from her was an ongoing investigation, not completed.
Well, my thoughts as all this was going on and et cetera, I'm just. Obviously, I'd like to make sure that the CPS issue is resolved. But also I was wondering if you believe there's any utility to have a front of the court investigation in this.
I would invite that, Your Honor. I think as many of these cases are when you have minors making allegations, and the only way that that information gets to anybody is through the child, with all the limitations in court and so forth. It certainly very well may be beneficial to have a third party investigate it and make a recommendation as to what would alleviate whatever problems there are. If there are abuse problems, there needs to be a remedy to it. If there are problems between a son and a father that puts the son in a position, I don't want to go with the father, that needs to be alleviated also.
Your Honor, I would object to, while normally I think that's a great idea, we've already had multiple professionals look into the situation. We've had the police, we've had CPS. I don't want to bring in another third party, especially since this child has been completely isolated from my client for 5 months now. My client has had almost zero contact with this child. This child has just recently brought up these alleged abuse allegations. This is completely new. And
As of 4 months ago, Your
I'm
Honor.
talking, Mr. Schaefer, you had your chance, I'm talking now. But I would object to
I
that
thought you
because
had-
my concern is that this child, again, has been completely isolated from my client. He's had everything that Ms. Bailey wants put into his head over the last 5 months. I don't think a CPS investigation at this time would be appropriate. I don't think it would be equitable to my client because this child just hasn't any contact with dad.
Well, apparently, court doesn't have any control over CPS investigation, and if that's ongoing, there's nothing the court can do to, again, intercede in that. My concern is maybe getting the front of the court involved and doing something in that regard so we can see, if there's any basis to anything and get, I guess you just say objective view in this matter. So, and as you say, Ms. Greenlee-Cora, normally you would welcome that, but in this case you don't want it. So
I don't think it's appropriate because I think this child has been completely alienated from his father by mother over the last 5 months. And I think that anything that comes out of this child's mouth is going to be tainted by whatever Miss Bailey has told him.
If I may respond.
yes, go ahead.
Your Honor, there's no indication of that. And again, I don't think opposing counsel has any basis for that other than suspicion. And that's the same problem we've got when a child makes an allegation against a parent. It's the same problem that Ms. Cora has with the speculation. She's not in that home. She doesn't know what it is going on. All I can tell you is that my client's position is she's gotten these allegations. She's doing what she's trying to do for the best interest of the child. But a friend of the court is going to be able to talk to everybody and do an investigation and make a recommendation.
Well, my thought is if we proceeded with a front of the court investigation, that the intent would be of the court also is to get some counseling involved, and that might give us another perspective as well in the interim. Ms. Greenlee-Cora, what's your thought as far as a counselor to be involved?
My client is certainly on board with having counseling that has been wanted since the beginning, but Miss Bailey, again, objected to this child talking to anybody. So here we are today, 5 months later, this child hasn't had any counseling to deal with any of the issues. He's been completely kept from his father, who has raised him since infancy. Father's had sole physical custody of this child for almost his entire life. Again, I've been on this case since the very beginning, 2011. I know the history of this case. Mr. Roth has been the only father this child could count on. Miss Bailey now jumping in, I'm sure it makes this child excited that now she wants to be involved, but she just hasn't been.
Okay.
Your Honor, we take exception to a lot of those things. There was a time, in fact, my client had custody of this child. It got changed, but she was the the physical custodian at one period of time that's gone back and forth a number of times. So there's a lot of history to that. I agree, but it's not totally accurate. And as to the counseling, I don't know what opposing counsel is talking about, that my client has opposed counseling. My client is in favor of counseling for the benefit of the child, has been, will be. And it's been a 4-month period that the child has told my client he refuses and fears going back with his dad. That's a problem that needs counseling.
Okay, well, obviously, there's a lot of issues, and we've had, court does notice, Mr. Schaefer states that back in 2012, his client was granted physical custody. That changed then in 2014. So there has been some changes, and I don't want to get in a position where we continue to be here every couple of years and going through all of this. I'd like to get it resolved, once and for all, I guess. And so at least this court feels that with a front of the court investigation, that would assist this court as we move forward in making an appropriate and proper decision in this matter. So what the court is going to do, at least for today, I'm going to adjourn this matter, refer the matter to the front of the court for an investigation and a recommendation. And at the same time, the court's going to order that there be counseling in this matter between the parties and the child and any other third parties that the counselor deems necessary and appropriate. A court will order that the parties would each pay 1/2 the cost of the counseling that's not, again, covered by any insurance. Mr. Schaefer, I guess I'll ask you, you brought the issue up for us. Who would you recommend as a counselor in this matter?
I guess I like a little time. Some of them are out of business, not going forward, and some are really backed up. Perhaps Ms. Core and I could try to come to a solution of that. Haugen's office.
Do you have any recommendations at this point, or do you want to take some time to speak to Mr. Schaefer and come to an agreement?
I'm going to talk to Mr. Schaefer and my client to see if we have any insurance coverage at all, or what we can qualify for.
Okay.
But I do want to note that I guess I want to address too, is this counselor going to be in Battle Creek? Is this counselor going to be in Allegan? This child has lived in Allegan since 2014, and this child attends Allegan schools. And I want to address where this child is going to school today before we adjourn.
I'll answer that right. He is in school. He's been in my client's possession as admitted since May, so it's a deal there. We got a one party here in Calhoun County. One is moved to Allegan. The jurisdiction is in Calhoun County. I would think it ought to be as convenient or as inconvenient to both of them in that regard. It's going to be the parents' inconvenience rather than the child's, I believe.
Well, I'll leave the issue of the counselor up to the attorneys to come to an agreement. If you can't, then bring the matter. Contact my office. We'll have a status conference and we'll address it at that particular point. So,
Your Honor, as to the schools, I want to drive home that back in August, before school started, Ms. Bailey was ordered to take this child to Allegan schools and violated that order completely, and apparently enrolled this child in Northwestern without telling my client where his child is going to school. This child was an AB student in Allegan County and needs to be back in the school that he's been in for years. And we would request today that Ms. Bailey be ordered to take this child back to Allegan County schools where this child's been enrolled for years and years.
The child's enrolled now. He's an AB student at the moment. He's doing very well. And we'll make that information all available to her to check out.
okay. I don't know what we would gain the utility of, again, ordering him into Allegan schools if the child's not going to be in Allegan. I just don't
He's already been ordered to be there, Your Honor.
I understand that. And as Mr. Schaefer says, that she did take him back, took him back on September 11, 2023, at which time neither the defendant nor the police officer was able to get the child to go with the defendant. So taking that into consideration as well, court's not going to place any additional orders in place at this time. We'll just leave the matter where it is now, pending the investigation, and then we will address it at the time that we have, again, the subsequent trial in this matter. Anything else, Ms. Greenlee-Carr?
Yes, Your Honor. Just 2 points. The first point is for that this court hasn't heard any testimony about what happened on September 11th. My client showed up and Miss Bailey told the child he didn't have to get out of the car. That is not delivering the child. Secondly, we need to address temporary parenting time. This investigation is going to take another 2 or 3 months, maybe longer. What is the parenting time going to look like in that interim? Is my client going to again miss out more time with his client, with this child, when he's already missed 5 months?
Mr. Schaefer, what's your response?
Your Honor, we take exception to the rendition of 11th. We've got 2 witnesses that are going to be there, that the child was made available to the child. That statement was not made.
Okay.
As to, Your Honor, we are willing, and if it's able, to have contact with his father. But the problem is, I believe, is that getting the child to be able to have contact with the father. I would respectfully suggest that we get them into counseling immediately and let the counselor make the decision as to what contact there is with the father. If the counselor says we're at a point and the counselor can get the child to meet with the father, that would be something that would be important, I believe.
Well, I'm not going to let the counselor make the decision, as you suggest, Mr. Schaefer. I'll let him make a recommendation, but the counselor is not going to make the decision as to
Okay, I agree. But I think that input would be beneficial. I mean, the court could say, Caden, you see your father at night, and Caden says, I'm not going to see my father at night. Who's going to be the one dragging Caden to see his father?
Your Honor, I also want to indicate we've got evidence today. You have exhibits in front of you with Miss Bailey clearly saying, I am not bringing this child to you. I am not bringing this child to you, not today. She has withheld this child purposefully from my client, alienated my client from this child.
We disagree with that, Your Honor. We've got witnesses to the contrary.
Thanks. Well, there's a lot of issues that we're going to have to sort out, but I do want to get the child in counseling. We'll give you a week for the attorneys to try to resolve the issue of counseling, and then find out how quick we can get the child into counseling. And then what'll happen is, why don't we do this? We'll set about 2 weeks. We'll set a status conference. We'll talk to the attorneys and find out where we're at that point. Then the court will do a further order at that time, depending upon when we can get the child into counseling.
Does your Honor wish one of the attorneys to prepare the order?
Yeah, why don't, Mr. Schaefer, I'm going to ask you to do that. Prepare that. And what we'll do is we'll set up for a status conference about 2 weeks and see where we're at that point with the counseling, because I'm not going to just indefinitely not allow any contact between the defendant and the child. So there's going to be contact. If we can get the child into a counselor right away, I mean, within the next couple of weeks, that'll make a difference. But otherwise, the court will have to take some other action in this particular case. Okay. Anything else, Ms. Greenlee-Carr?
No, Your Honor.
Okay, Mr. Schaefer?
No, Your Honor. Ms. Carr, after you talk to your client, would you be willing to give me a call this afternoon so we can or this morning or this afternoon so we can talk about what counselor would be appropriate?
Yeah, I've got this morning blocked off for this, so I will call you this morning after I speak with my client.
Okay, the court will also, in this matter, the court will order that the parties would each bear 1/2 the cost of the front of the court investigation as well. You can put that in the order. Well, I'll put that in the referral order that we have.
Okay, very good.
Okay,
Thank you.
thank you. Court will conclude this matter now at 9:03 a.m. You're free to go. Have a good day.